So thanks everyone for coming. I'm Luke Herron. I'm the managing editor of the Law and Political Economy blog. This is the fifth of our Mapping U.S. Law and Political Economy series, the fifth and penultimate of our series. And I wanted to start by saying a bit about the concept of the series as a whole and what we still have coming up. The structure of the series is loosely in conversation with an article co-written by the faculty directors of the LPE project, Amy Kapczynski, David Graywall, Jed Purdy, and Sabeel Rahman, recently out in the Yale Law Journal. This article, titled Building a Law and Political Economy Framework Beyond the 20th Century Synthesis, among other things, tells the story of the transformation of law and legal scholarship over the past 50 years, accounting for the meteoric rise of law and economics in US law schools, the false separation of the economy from politics, and the erasure of critical traditions and questions of power. What Corinne Blaylock and I hope to do in designing this series was to move from this overarching story to accounts of specific areas of law by talking to LPE scholars about what happened in their specific fields. And so we have asked some of the most exciting LPE and LPE adjacent scholars to essentially be interviewed about their fields, to historically situate the current state of the law, to discuss to what extent and in what ways neoliberalism did or did not transform their field, as well as point to the approaches and ideas they feel best challenge the current settled order. No, sweetie, excuse me. My daughter wanted me to spell her freshly brushed teeth. So sorry. Next week, we have one more event in this series. It's the final event for the summer. We'll talk about US empire with Asla Bali and Aziz Rana. But tonight, we are ecstatic to have Jonathan Simon and Shaun Ossei-Owusu, and I'll turn things over to Corinne and get us started. Thanks.
Thanks so much. So I'm actually going to let Jonathan Simon and Shaun Ossei-Owusu take over in just a moment, but I just wanted to give a brief introduction. As Luke mentioned, we're thrilled to be joined by these two incredible scholars who work and teach at the intersection of the criminal legal system, political economy, and race. Shaun Ossei-Owusu is the Presidential Assistant Professor of Law at the University of Pennsylvania Law School, and Jonathan Simon is the Lance Robbins Professor of Criminal Justice Law at the University of California, Berkeley. In their scholarship, both Professor Ossei-Owusu and Professor Simon, each in their own way, masterfully draw out submerged histories of race, materialism, and the carceral state as a means of reimagining the political horizons of the present. And so we've invited them here tonight to help us try to do precisely that, to historically situate the current state of the criminal legal system, to trace how we got here, and to discuss what scholars and practitioners can do to aid the struggles for transformation. Thank you all so much for coming, and now I will turn things over to our presenters.
Thank you, Corinne and Luke, and let me, for the only time tonight, I hope, speak for both Shaun and myself by thanking all of you for joining us tonight. It's just an exceptional honor to speak with a group like this under the extraordinary circumstances we're in, and I can't think of maybe one time in my life where I felt so much fear and so much hope all at one moment. And it's a very ecstatic and weird moment, but it's also a very epic moment. And so to have a chance to study and learn with you is a real honor. And I'm especially grateful for Shaun's willingness to do this with me. One of the things, I don't know if we'll be able to get into it tonight, but that I think is one of the biggest cleavages in our society is between generations. And we often don't surface that, even though we used to talk about the generation gap. We wanted to make this kind of a dialogue in the scholastic tradition, except that I'm no longer doctor and student, but I guess doctor and doctor here. But I thought it would, just because you can easily find out about our intellectual CVs, etc. But I'm always curious what brought people into the subject fields they're in. So I'll take this opportunity to ask Professor Ossei-Owusu, how did you decide to, draw your formidable intellectual powers onto the criminal legal system across a couple of degrees?
Well, thanks for the question. And I just want to echo your comments and thank Luke and Corinne and the folks at LPE for inviting me and inviting us to have this conversation. So to the question about how I kind of got into kind of putting my intellectual energies into criminal justice issues, I would say it's a kind of byproduct of my personal and intellectual background. And so I was born and raised in Bronx, New York, so born in the 1980s. I came of age in the 1990s. And so this is the kind of tail end of the crack epidemic amidst broken windows policing in what was essentially an exclusively Black and brown community. It was a segregated community. And that's still strange for me to even think about, given how New York City is understood as being a cosmopolitan place, and the work that gentrification is doing in the city in these days. But I remember heading off to college in the early 2000s and being vaguely familiar with the narrative of crime decline in New York City in the 1990s, and understanding that as being true kind of in terms of the demographics of criminal justice statistics, but not really feeling like that was the case in the neighborhoods that I lived in and walked through. But it's when I went to college at Northwestern, and it was there I started to get a little bit more language and vocabulary for some of these questions around race, poverty, inequality. And it kind of gave me texture to some of the things that I witnessed, saw, vicariously understood by way of other people's experiences. And so after college, I came here to Philadelphia, taught for a little bit, did a master's program, and that really got me interested in higher education and academia. So I applied to a PhD program in African American Studies at UC Berkeley, and my interest in race and poverty, criminal justice inequality crystallized. And that's where I kind of got deep into the literature and critical race theory, as well as a spate of books that came out during that time. So your book, Governing Through Crime, came out, The Weak for Punishing the Poor. So two kind of heavyweights on my campus doing issues tied to criminal justice, as well as the kind of new Jim Crow. So it really was able to kind of fuse my interest in critical race theory, law and society, and kind of broader issues on criminal justice. And at the time, and I think it's still today, much of the intellectual energy was focused on, appropriately, on police officers, prosecutors, and judges, but it felt like public defenders were left out, and at least to me, like theoretically, they're the only ones that have the interests of the criminally accused, predominantly poor people. They're institutionally tasked with representing them. So I really got interested in public defenders, matriculated into the law school at Berkeley, where I was fortunate to have you for criminal law and as a dissertation advisor. And have been working
on my one high rating.
Yeah, and so been working on criminal justice issues since. So that's kind of the short, kind of intellectual, personal trajectory. And I'm curious about how it took shape for you, because you also did a JD and a PhD at Berkeley, but I'm sure your experience was different.
Well, thank you so much for that. And you've already begun to kind of lay out a history line that I hope we can fill in with, and you've already filled in some of the terms there and whatnot. And I do want to spotlight for a moment in terms of academic categories and departments that, African-American studies, I don't know how many universities it exists at, certainly not everyone. It's often overlooked and whatnot. To me, I've begun to notice, actually belatedly in the last decade or so, maybe meeting you being one of the factors, that it has become a kind of, it might be too strong to say anti-criminology department, but a kind of, a node of intellectual traditions and epistemological approaches that don't accept the pathologizing framework of so much of American criminology, which has actually influenced so much of American criminal law as well. So I'll be very brief, but I identify kind of as a criminologist, notwithstanding what I just said, because it's such a problematic field and because I think it's often acted as a kind of evil Svengali to criminal law. That's probably a bad cultural reference too, but just a kind of evil twin to criminal law that helps to lead it in bad directions, which I'm hoping to to help resist as part of that tradition. But two dates that you mentioned 1980s, 1990s. So let me back up a little bit. So two dates, 1968 and 1982. 1968 was the last time I felt this hopeful and this scared. And I was a pretty alert, like 9-year-old, because my parents were very involved in various aspects of the anti-Vietnam movement. We were in Bloomington, Indiana, which was a frontline campus for the struggle in those days. And watching the murder of Martin Luther King in April of that year, and then Bobby Kennedy, who we had enormous hopes for as somebody who could maybe lead the country out of 1968 into something that would have avoided the neoliberal place that we're now in, a kind of social democratic reboot of the 60s liberalism. That died in California, a few weeks later. And that summer, the Democratic Convention that ultimately nominated Hubert Humphrey took place under military, conditions. And I watched a lot of that, mostly on TV, fortunately, but enough of it during the day in person to remain terrified of police, for one thing, for the rest of my life, but also aware of how much violence changed our history and in ways that we'll never really understand, perhaps. The second year is 1982, when more or less I read Michel Foucault's Discipline and Punish, I think, for the first time, and also ended up in the Santa Rita County jails, sort of dorm facility where they often put college protesters when there were too many of them to put in a cell. And really was the first incarceration experience I had had in my life. First time I'd seen so many Black and Latinx people since I had come to the Bay Area 5 years earlier. And I was especially struck as I walked into the chow hall at a big sign that read, inmates are to remain silent during feeding. And I just, kind of let that language seep into me a bit and decided I would probably have to get a couple of degrees to just think about how the criminal legal system functioned in a democracy. I didn't have mass imprisonment or any of the current elements, which are a little bit in the future. So let me stop there with the bio, because I'll come back to some of that history in talking about neoliberalism.
That's fascinating. I didn't know that in terms of what inspired you to do this work. And I guess since we're kind of in a mode of history, I wanted to ask/invite you to kind of chat about neoliberalism. It's obviously a contested term, but just wanted to invite you to kind of chat about that and its relationship to the criminal legal system, just so everyone here is kind of on the same page.
Well, I'll take the invitation, and please, cut me off if it goes on too long, because I want to get your take on this as well. And I agree with you. All these terms are problematic. I mean, there's no, I don't believe that social science develops terms like economics has for efficiency or rationality that are then kind of stable things that never change. Nietzsche once said that anything that has a history can't be defined, or at least can't be precisely defined. It's always going to be a blur. And that's certainly true of neoliberalism. But what I think is valuable about it is that it sets out what I would think of as a kind of horizon of political economic struggle, really, and contestation that doesn't determine law or legal systems or other systems in any kind of rigid or deterministic way, but creates a horizon in which a lot of action, is certainly constrained and motivated, and a lot of the dynamism can be understood. So if you ask, is it useful? And actually, one of the things that can help it not be a problematic term is to always try to use it in site-specific ways, like neoliberalism in Buenos Aires may not be neoliberalism in Singapore or in Chicago, and let alone in different fields of academia. So to ask how it applies, as this whole program has done, has been, I think, very productive. But my essential answer is, oh yes. I mean, it seems to me, if once you think about how political economic struggle, new forms of capital accumulation, and then the resistance that they inevitably, generate, or other, I don't want to simplify it too much, but let's leave it at that for now, almost always have in our history that I'm aware of generated significant responses from the criminal legal system. as a first order political response to economic, essentially, struggle and vulnerability, right? Vulnerability. I'm grateful to, the fact that when I came into academia as a student in the 80s, we were basically riding on a wave of political economic history of the criminal legal system by people like E.P. Thompson, earlier work by Ruscha and Kirkheimer, the Frankfurt School scholars who wrote Punishment and Social Structure, was rediscovered in the 70s. Molossi and Pavarini, whose book, The Prison and the Factory, looked at the birth of the prison and its relationship to industrialization. And of course, Foucault's Discipline and Punish. So this was already a very familiar way of thinking about the criminal legal system. Since then, of course, we've had a great deal of great scholarship on the sort of more conventionally defined time period of neoliberalism, the 70s, as a turning point in the criminal legal system. And one thinks of work by folks like Ruth Wilson Gilmore's Golden Gulag about California, Marie Gottschalk, Loic Vacant, who you've mentioned, David Garland. To me, the sort of text that always bears rereading and could be rewritten as 1,000 different dissertations to this day is the great Stuart Hall's Policing the Crisis, which he wrote with a number of colleagues. Hall, who was a Jamaican British political theorist who helped to found critical race theory in Europe, as well as media studies and cultural studies, basically discovered Thatcherism in its embryonic form as he studied how muggings in London became this fulcrum by which the sort of white working nativist class of Britain were able to experience their own economic crisis as a racial experience, basically, and invite a law and order, response by the state. That book was really the first to see that, and at a stage where it was invisible, to most people. Very briefly, so to turn, at least, most of our metaphors are spatial. I think it has to do with the way our brains evolve, but I won't go down that rabbit hole for the moment. The turn implies that you're turning away from something. So what were we turning away from? Well, again, it's harder to define for the criminal legal system, partly because unlike sort of our more conventional legal topics, a lot of this system, policing, corrections, probation, parole, are sort of invisible to the law school world and to most legal scholarship, although that's becoming less true, and one of the things we can talk about being excited about. But broadly speaking, scholars like Garland have spoken of the sort of mid-20th century synthesis as a welfare penality, a kind of notion that the criminal legal system was an arm of essentially a welfarist version of liberalism that sought to tame capitalism with things like social welfare, but also with kind of ameliorative policing and corrections. Now, the existing schema we think of today as the criminal legal system really came into being mostly in the interwar years, the 1920s. By the end of by the beginning of the Depression, at least bigger cities had, in addition to courts and prosecutors, police and prisons, things like juvenile courts, probation officers, parole officers. Something was beginning to emerge that later would be called the criminal justice system. Not yet. Sarah Mayo is right about that, if I'm pronouncing your name right. That gets articulated later in the war on crime period. A lot of this has to do with eugenics, and I don't have time to really talk about this now, but eugenics is the great framework that stitches together the political economy issues of that period, which had to do with labor unrest, international competition, military competition among capitalist powers like Germany and the United States. But as James Whitman shows so powerfully in his book, Hitler's American Model, the US was the #1 eugenic superpower in the world, and a lot of that was criminal justice, or a lot of that was expressed as criminal justice. Segregation laws were criminal laws, anti-miscegenation laws were criminal laws, laws against homosexuality, which got ginned up in the eugenic era, were criminal laws. So this is a big criminal period. Prohibition is a huge set of criminalizations. What's interesting to me about all that is by the time the neoliberal turn happens, this settlement around eugenics has gotten reframed as rehabilitation, right? So it has this kind of a very softer, ameliorative form. It's interesting that lots of people, including imprisoned people like George Jackson, the prison Black Panther leader who died at San Quentin in 1971, never saw it that way, always saw it as a racist system. Whether they understood the history connecting it to eugenics, they may have, because actually San Quentin had like a doctor that was operating on people's gonads as late as the 50s in order to continue this kind of eugenic synthesis. So part of what's ironic is that the neoliberal turn often looks like a conservative turn, repudiating a kind of liberalism that we should go back to. And I would highlight that because I don't think we should go back to eugenics for sure, or what came out of it. Very briefly, like, we're talking neoliberalism as political economy, like what actually happened in the criminal legal system. And here I'm just going to throw out some labels and we can talk about them in the Q&A. And again, you have to look at the different parts of the system. In penology and corrections, you get what Malcolm Feely and I call the new penology, a shift from talk about rehabilitation, even if just talk, to risk management and mass incapacitation. In policing, you go from the mid-20th century idea of patrol and dispatch, technology-driven, to aggressive sort of counterinsurgency style policing, militarized policing, proactive policing, broken windows policing, sometimes under the euphemism community policing, ironically, quality of life policing. In sentencing, you go from discretion and indeterminacy to a kind of carceral pinball machine of determinate and mandatory and enhanced sentence options, but it varies across the country. In substantive criminal law, you go more or less from the kind of model penal codes, pieties about mens rea, to any means necessary, laws like the material assistance, laws used to heavily criminalize any contact with terrorist organizations in the post 9/11 era. Or for instance, Florida's legislature stripping the mens rea feature out of the drug delivery law. So if you don't know it's drugs, too bad, appeal to the prosecutor. It's an affirmative defense. Very briefly, there's nothing in the academy that is equal to law and economics exactly in terms of an intellectual settlement. There is, of course, the classic Richard Posner article of 84, 85, where he tries to lay out criminal law as just a branch of law and economics. And that's been somewhat influential, but I don't think it's really kind of made the field coalesce around it the way it has in other fields. But let me point to two other trends that I think in a way, could serve as neoliberal consensus points. One is in the field of criminal law philosophy and moral philosophy in particular. A lot of criminal law professors in the 80s and 90s, a lot of the scholarship was dominated by moral philosophy. And as it did in the 19th century, sort of a moral philosophy view of crime can often play well with, new forms of capitalism that want to transfer responsibility onto individuals, that want to highlight the limits of people's ability to use necessity as an escape from property regimes and things of this nature. So I would view that whole cult of moral philosophy in criminal law theory as a kind of neoliberal turn. Likewise, I think there's a kind of neo-Benthamite kind of law and social science scholarship, and I'm not just I know it sounds like I'm dissing all of the scholarship. I'm not. All of it has its own bona fides. I'm just saying I think if I had time, I would try to show you why these fit well with and help to perhaps reinforce in the lawyers that we trained and the judges that we trained some of these neoliberal turns. Finally, is there really a political economy story here? In a phrase, I would call it the urban crisis. And here I would really recommend Ruth Wilson Gilmore's book on California, or some of the great urban histories that have come out over the last 10 years, Tom Segru, or 20 years, Tom Segru's book on Detroit, I think The Birth of the Urban Crisis. In a nutshell, what I used to think of when I was a high school student thinking about city planning as a career as the inevitable death of the big cities of America and their downtowns unless we could find some way to solve the problems of crime and disorder, etc., was really about the transition from essentially the Fordist industrial city of the mid-20th century to the global consumption-oriented sort of finance, tourism, academic research, city, New York, Chicago, LA, and San Francisco, Seattle of the Audis and beyond. much of what we think of as mass imprisonment and aggressive policing can be seen as part of an effort to essentially remove people of color from those areas and to also drive down the prices of those areas by making them seem totally undesirable so that big capital could accumulate them, at bargain prices, and big cities could rebuild using eminent domain, again, at very low prices. And look at Chicago remade itself. When I got there in 1968, Mayor Daley, who was not a neoliberal, but neoliberalism depended on strong kind of old school corporatist leaders to actually build its infrastructure. But he created what we now call the University of Illinois Chicago on the bones of several working class neighborhoods. He guaranteed the University of Chicago security if they would stay in Chicago, and they talked about moving the campus out of the city, partly by policing the area. So this is really about removal. And are we at the end of that process? And as George Floyd signaled that, I want to hear what Shaun thinks about it. But one sad way to start what could be a more optimistic conversation is it may not be needed anymore. If you see a movie like Last Black Man in San Francisco, I mean, it's been done. Essentially, the removal's been done. They have essentially destroyed most of the traditionally Black neighborhoods in the core areas of Seattle, the Bay Area. I don't know about New York, how far that is progressed, or in Los Angeles. So let me just hit the self-pause button.
Yeah, I mean, part of your comments, what they do is kind of help lay out the kind of development of the criminal legal system in terms of questions around political economy, as well as substantive criminal law and the role of legal academics, which is something that I hope that we can get to either in the other part of this conversation or in the Q&A, because I find that is often a missing piece of the conversation. And I think, when we think about the relationship between the criminal justice system and political economy, I think there's an important criminal procedure story too that kind of ebbs and flows with kind of questions around the welfare state. And so, I think about, when I think about criminal procedure, it's hard to generalize because criminal law and criminal procedure is often state-based, and the Supreme Court kind of acts as an outer limit. But that is where many of the highlights are, and it very much starts, I would say, with the Hughes Court, substantially. So there are obviously decisions before the Hughes Court, and so think about Strouder versus West Virginia in 1880, dealing with race and discrimination in juries, or you think about Bailey versus Alabama and debt peonage, Moore v. Dempsey in 1923, which has to do with what a court says, and it's surprising they have to say that in 1923, that mob-dominated trials violate the 14th Amendment. But it's really with the Hughes Court is where I think you start to begin to see changes. In the Hughes Court, I think in legal scholarship is generally understood in more constitutional terms, and in its relationship to the New Deal. But there are also developments in criminal procedures. So you think about, Powell versus Alabama, the famous case involving the Scottsboro boys, where for the first time, the court says, capital defendants who can't afford an attorney have to be provided with one by the state. And that case is decided the same week FDR is elected. And thereafter, the court really begins to intervene in cases involving Black defendants in the South, but poor Black defendants. So this is a story that kind of Michael Klarman talks about. But you think about, a case like Brown versus Mississippi in 1936, having to deal with involuntary confessions, or Chambers v. Florida, a couple years later, having to deal with involuntary confessions by way of duress. It's a Supreme Court kind of stepping in these cases and trying to involve itself in state criminal justice. And the 1950s or 1940s are somewhat, but not completely dormant. But then beginning in 1956, you have Griffin versus Illinois, a case involving transcripts, payment for transcripts for criminal defendants who want to get appeals. And the court says you can't. This is the Warren Court. This is one of its first early cases. The court says, this is a violation of due process and equal protection clause. And then by the 1960s, it's a highlight reel, and this is happening at the same time as the war on poverty. And so you have the famous Gideon versus Wainwright case, where the court incorporates the right to counsel to states and all of Gideon's progeny, which extends the right to counsel to critical stages. You have Miranda versus, you have the famous Miranda case, where the court picks up the baton on its earlier cases involving involuntary confessions, recognizing the role of race and poverty in the criminal justice system, as it does a couple years earlier in Matt versus Ohio, which has to deal with the exclusionary rule. But beginning in the 1970s with the Burger Court, and this is where the kind of starting date for neoliberalism begins, the court begins to rein it back. Begins with the Burger Court. This is a story that Linda Greenhouse and Michael Gratz have written about. The Burger Court's kind of seen as this transitional court between the Warren Court and the Rehnquist Court. But part of what they're trying to do is kind of scale back what is understood as being the excesses of the Warren Court at a time when, immediately after real increases in crime in the 1960s, as well as dealing with, what various kinds of economic recessions in the 1970s. And then by the time we get to the Rehnquist Court, or late Burger Court, early Rehnquist Court in the 1980s, that's where we get many of the cases that we read in criminal law and criminal procedure, the cases like Strickland versus Washington, McCleskey versus Kemp. Moving into the 90s, and you have the Wren case. A lot of these cases where the court is essentially saying that questions around race and poverty are not going to be legally consequential. And this is happening amidst mass incarceration. And so there's an interesting way that criminal procedure is interfacing with questions dealing with substantive criminal law, evidence, which oftentimes is in the background but not discussed as much, as well as political economy.
That's fascinating. We have to circle back sometime and think about that arc from the Hughes Court to the Warren Court is essentially paralleling what I described as the modern eugenic settlement, right? And the Hughes Court and the Taft Court, affirms eugenics in, Buck versus Bell. And at virtually the same time, they're, intervening in Mississippi. They're saying, well, it's better to just sterilize the mom than hang the progeny. And generally, there's, I think, a eugenic vision that we can have a more scientific but racist criminal legal system that will replace the violence of the nearly lynch-like justice being, applied in these southern states. Unfortunately, that anti-blackness of eugenics, which Khalil Muhammad discusses in The Condemnation of Blackness, never goes away, even though the Warren Court clearly is trying in its own way to move away from it, but it never names it as such. Since we're talking about cases, and we've been on you brought us down to a much more concrete level, but let's get even more concrete. What would you think of as kind of the leading cases of sort of neoliberal criminal procedure or criminal law?
There's so many.
Or leading laws. You can mention laws too if you prefer them.
It's I think. So I'd say a couple cases come to mind, some more notable than others. A case that I think about a lot is, one called Polk County versus Dodson. And it's a Section 1983 case, but it has to deal with public defenders. And there, essentially what the court says is that public defenders, even the public defenders that are financed by the state, are not state actors. And so that happens. Polk County versus Dodson is 1981, I believe. Then a couple of years later, you get Strickland versus Washington, where the court creates its notorious ineffective assistance of counsel doctrine. And I think the combination of those cases, what they really do is, one, some people argue, create the conditions for poor lawyering. But I think on a larger level, it's kind of at this intersection of the welfare state and the penal state. And that's a conversation that comes up in neoliberalism, in conversations about neoliberalism as it relates to the criminal justice system. And so part of the idea is like, is to kind of have an emaciated welfare state and a robust penal state that, I think Vacan says that the strong right arm of the state and the left arm of the state. And what's interesting is like, and part of the reasons why I find public defenders so interesting is that they're kind of situated in the middle, in that, they're, and I talk about this in an article, right to counsel is essentially a judicially created welfare benefit. But part of what those cases do is really limit the range of what public defenders can do in service of a goal of punishment. And that makes me think about kind of the ways Bernard Harcourt has talked about neoliberal penality. The idea is that the state should not be involved in questions involving markets. But when it comes to the penal state, that's a place where the state should be active. And I think public defenders are in this weird interstitial space where the penal state is very active, but there's also a retrenchment. And so those are kind of two cases that come to mind. But there are others. I mentioned McCleskey, I mentioned Wren, and I think those are important because those are cases where the court is essentially saying that race is not significant in the criminal justice system, precisely at a time where there's mass incarceration, where the criminal justice system is understood primarily as managing poor Black and brown and white people that are accused of crimes. And so I think, I would say those are the cases that kind of stand out to me when I think about, race, political economy, and the kind of highlights of the Supreme Court. But I wonder if you have.
That's such a great list. I won't try to add to the cases. I'll just, because this is a world of statutes as well, let me just throw out my nomination, which would be for the Armed Career Criminal Act. And in his forthcoming book on violence and the law, David Sklansky has a brilliant chapter on the sort of genealogy of this Frankenstein law that was carved out by your Philadelphia hero, Arlen Specter, out of a kind of vaguely eugenic fear for the real career criminals out there. But they ended up kind of selling it as a gun control sort of law. And it allows people who have essentially committed drug crimes, but if at any time they've used a gun in a crime, they can be sent to prison for life, basically. And it's so vague that the Supreme Court has, I think, decided, certainly close to a dozen cases trying to sort it out. And I think recently threw up its hands on it. But it's a fascinating example of that. I think it's really important to talk about pedagogy, because it may be that criminal law's main task is to put people to sleep about the criminal legal system people who are going to be influential judges and prosecutors and legislators, because criminal law pedagogy doesn't really, the part I learned and the part I see in the case books doesn't necessarily resonate with what we've been talking about. So what are your thoughts on where it is and where it might go?
Oof. This is a question that gets me somewhat riled up, in part because I'm writing on it, or wrapping up a paper about it. And I think, when I think about, I think that the criminal justice professoriate is often left out of conversations about, mass incarceration, and I think it's pretty consequential, given that some of the people that we are training are going out to be public defenders, prosecutors. Some are going to clerk for judges. Some are going to go to firms and then become prosecutors, become judges. And there's a way that, we teach in the criminal justice curriculum that's not tied to some of the most pressing issues in the criminal justice system. And so this is kind of tied to the Britton Purdy et al. Article on political economy, in the ways that we don't talk about these questions about poverty. More generally, when when you think about criminal law, maybe a criminal law casebook has a discussion on the poverty defense, criminal procedure, a little bit more likely maybe when we talk about the Sixth Amendment right to counsel, talk about bail. There's starting to become more coverage on questions around excessive fees and fines. But it doesn't, questions around poverty, as well as race, don't figure prominently into the criminal justice curriculum. And I think this happens also by way of like how we talk about crime, and it makes me think about an article that you published, I forgot where, because you published a lot. But you had this interesting line in there where you said that, you don't spend too much time talking about the theories of punishment in your criminal law courses, because it might imply that the criminal justice system has a sense of rationality that it doesn't have. And I think there's a way that, I remember reading that after teaching my course. And I like to think of myself as teaching my course in fairly critical ways. But I think there's a way that we don't actually address some of the pressing issues in the criminal justice system, in part because of, our reasonable concern to want to teach people the rules, the doctrines, the tests, the defenses, much of which is tied to, legitimate concerns around helping produce practice-ready attorneys. But I think it does a real disservice to the people that we end up sending to work into the criminal justice system, whether it's the prosecutors that we understand as being key sources of our penal status quo, or public defenders who are, fighting to protect the rights of the criminally accused. And so one of the things I try to do in my class is, cover the material that the students need to learn, but introduce them to materials that'll question some of the kind of common sense assumptions that we have about criminal law. I have them read portions of this great book called Dorm Room Dealers, which gets them to think that, crime doesn't just occur in quote unquote high crime neighborhoods, but it's happening on the frat row of whatever college you went to, assuming that they have fraternities and sororities. And that book just talks about, the under-policing of college campuses, notwithstanding the drug use and sexual assault that we know happens in those places. And, I spend the last week of my class talking about, contemporary issues in criminal law, where, we talk about white collar crime, we talk about digital crime, in part because I don't want my students to have the impression that criminal law is just black and brown street crime. And so I think when it comes to questions of pedagogy, we have to think beyond the boundaries of the doctrine and kind of black letter law, and find ways to inform, or find ways to teach our students about what's happening in the criminal justice system, because I actually think it's a version of pedagogical malpractice for law students to be leaving criminal law, leaving criminal procedure, leaving evidence, without having a full understanding of how those areas of law help produce some of the problems that we have in the criminal justice system.
Do you have a sense of like where in the course one could center Black lives and the harm done by the criminal legal system in Black communities? Is that part of what you include at the end of the course? Are there places within the heart of the course that you think it can be introduced?
Yeah, I think I would say, that question operates on a couple of levels. I think at a bare minimum for the professor that is disinterested in disrupting what they already have in terms of their teaching materials, at a bare minimum, just the beginning and the end, just in the beginning of the course, is just to say, like, I'm going to teach you, and I told my students this, I'm going to teach you as much criminal law as possible, but I also want you to have a sense of some of the policy implications of what's happening. So I think there's that. And then at the end, I think more substantively, I think, surely questions around race can come up when we talk about reasonableness, when we talk about self-defense, when we talk about void for vagueness, when we talk about the death penalty, if we talk about the Eighth Amendment besides the death penalty, which doesn't happen as much, I introduce possession into my class because it's not in the case book. So I think it can come up in different parts of the book, but different parts of the course. But I also think part of it is just around case selection. The harder version of that is the easier version of that, I use Cynthia Lee and Angela Harris's criminal law case book, which I think does a good job of, having discussions around race in the case selection and in the notes, so that introducing those things doesn't appear to be additive. But, I think my sense, and I'm junior, but I studied the legal profession. My sense is that case books are kind of like coffee or cocktail or your favorite Jamaican restaurant. Like, you have a thing and that's what you stick to. And so for people who don't adopt that book, or, Cynthia Lee and Song Richardson's criminal procedure case book, which I haven't used, but I've skimmed through and people have talked about in laudatory terms, part of it might just be about, having supplemental materials and rethinking the course. And I do think that this pandemic, which is forcing professors, because classes are being downsized if they're meeting in person, or it's hybrid or just online, I think it's an opportunity for professors to really rethink and rejigger the class in ways that speak to at least the kind of public statements law schools, law professors, and centers are making around being more attentive to issues of racial justice, class inequality, sexism, etc. So I think there's a variety of ways that it can be done. Professors are smart. We learn areas of law for grants and for papers in 6 months, a year, 18 months. I don't see why law professors can't be intentional about bringing in questions of race and gender, sexuality, and poverty into the classroom. I think it's in part, not fully, but in part questions of kind of intellectual commitments.
No, I think that's an excellent, inspiring moment to perhaps turn it over to our questioners, and maybe we can talk about the future in our responses to those questions.
Okay, so let's get started. So the first question comes from Alon, and it's for you, Professor Simon. It says, you mentioned 1968 and this sort of combination of a sense of dread and optimism. Were you exclusively referring to social movements in the US or globally? Because in the US, it ended up sort of dying and leading to a Nixon victory and a slow death of progress within the United States. In Mexico, likewise, it led to many student deaths and 32 more years of a one-party system under the PRI. France, however, the 1968 example where unrest led towards positive political changes and a stronger social state. The current movement has led to global protests. Do you believe genuinely that this global anti-racist movement could lead to changes in policy, or will it wither and lead to fear?
Wow, what a great question. And thank you for bringing the global perspective in, which I did not. And I mean, 1968 was a year of absolute global uprising. And you're right. In a lot of places, it led to, some of the democracy movements that eventually came to power in Latin America, began with that. And by the 70s and early 80s, were pushing back. And some of it was a reaction against that, like Pinochet in Chile. Very complicated moment. I am more optimistic now. Every country's different and it's hard to understand. One of the things I'm personally more committed to is trying to think about the US in the context of the rest of the Americas, because we share so much history in terms of genocide of the indigenous population, slavery, mass immigration, and then mass exclusion of immigrants and whatnot. And I don't have a good sense yet of how the sort of equivalent of Black Lives Matter is coming to the surface in places like Brazil, for instance, or Mexico as well. But here, I feel optimistic, partly because and I don't rely, I'm not normally somebody who looks everything to poll numbers, but I would say white support for Black Lives Matter is a kind of index of the legitimacy gap that the criminal legal system has built up, and it looks pretty strong to me now. For the first time since George Floyd's murder, it's over 50%, and it seems to be holding. And I think that in 1968, a majority of white people were racists. That's just a fact. Even people who thought of themselves as a kind of on the progressive side went to colleges that taught them that racism was basically a good scientific idea. And so it has made a difference that we have a different generation and that some of us boomers have shed at least a little bit of our eugenic training.
Okay, Professor Ossei-Owusu, this is for you. James Wynn asks, with the rolling out of the presumptive and mandatory mediation in New York, how do you see the restorative and transformative justice taking shape?
I'm not sure I know much about that rolling out. Could you repeat it one more time? Just want to make sure. It's a question about restorative justice.
Yeah, it says there's a rolling out of presumptive and mandatory mediation in the state of New York, and asks how you see restorative and transformative justice, I think, taking shape under those circumstances.
That's a hard question for me to answer. I won't even try to freestyle because I just don't know the background behind it. But James Wynn, please contact me and maybe we can chat about it. But I just don't have enough background.
I would just jump in for a second to say that, just the fact that restorative justice as a potential practice is coming into circulation in US discourse, I don't know, 10 or 20 years after it was circulating in the global south and in Europe much more is a very, very good sign. Again, a sign that the kind of anchoring of the hyper-punitive period is falling apart. But I think all of us need to be very worried about how the criminal legal system will morph into something else and co-opt potentially things like restorative justice to be part of the new face of how they present their services.
So I think this can go to either of you. It says the Supreme Court acknowledged that there is racism inherent in society in many of the affirmative action decisions. Why do you believe that they acknowledge that structural racism existed in affirmative action cases, but less so in criminal law?
So, I mean, I think it's an interesting question. I don't know that racism has not been necessarily recognized in criminal law cases. You know, again, I think about McCleskey, where the courts are actually just recognizing racial discrimination. But more recently, I think about Justice Sotomayor's dissent in Streiff. I think about the majority opinion written by Brett Kavanaugh, I believe, in the Flowers case. So I don't know that it's not being recognized. It is. I mean, it's been mentioned in affirmative action cases. It's been mentioned. Someone in the chat box said Gorsuch's opinion in Ramos. I think it's also been mentioned in housing cases, and so I'm thinking about the Inclusive Communities case in 2015, written by Justice Kennedy. I think there's a recognition of the role of race in some of these cases. I think part of it is tied in. No one's really investigated this. It's really speculative. I wonder how much of it is tied to, one, the composition of judicial clerks who are working for the justices, and perhaps their own recognition of the role of race and it filtering into the opinions. But more substantively, I just think that the role of race and national politics is beginning to become more undeniable, particularly within the last 4 years. And so to answer that question, I'd say, one, I'm not sure that it's just being mentioned in affirmative action cases. It is coming up in other spaces. But two, I'd say, perhaps I'd be curious to think about, who's clerking for the justices at the time that they're writing these opinions. I have some very speculative ideas about that. But two, part of it is just the fact that, given the kind of the nature of politics the past 4 years, race is becoming a more undeniable feature of, but not becoming, being understood as more of an undeniable feature of our political landscape. And then the question, the follow-up question really is about, what does that mean in terms of law's capacity to remediate these racial issues?
Jump in for a second to say that McCleskey is very chilling in this regard, because to some extent they do acknowledge, at least, that maybe this data shows that there is unresolved racism in Georgia homicide capital punishment system. But the rest of the opinion turns into a paean to discretion and basically says that, if we have to choose between a system that, promotes, that ends racial injustice in the criminal legal system and one that deprives prosecutors of their all-powerful discretion to decide who to punish, we're going with the prosecutors. And I think that's part of the neoliberal consensus in criminal law, that we'd like to have a less racist society, but we have to have a more secure one first. And we're going to accept what that takes, or at least what the police and the prosecutors tell us it takes.
So Vivek asks, we've seen public opinion shift against the police in wider recognition of their oppressive function. What do you think it will take to see a similar shift against prosecutors? What role can we as lawyers or academics play to bring about this more quickly?
Maybe I'll just briefly jump in and give Shaun a moment to catch his breath and say, first of all, don't count the police out, because not only, are the very local nature of the police mean it's going to be a battle in every city and every county, but also they have enormous power to sort of resonate with people's very deep fears about crime and punishment in America. I mean, American society became as punitive as we were through developing very powerful myths about crime, that the criminal legal system basically has turned into what sociologists call rational myths about that they're associated with them. So, we fear gangs, we fear disorder in our neighborhoods. Well, who's there to stop that? Well, the police are. And you can already see the pushback coming. So don't count the police out. It'll take a massive social movement to drive them out. But I agree with your point that we need to turn to prosecutors. They are very much a driving force behind mass imprisonment. You really can't easily end it without either taking away their power in large measure or replacing them with differently minded prosecutors. Both need to be done. I do think the public can be made to pay attention to this, partly because they've been looking at prosecutors on TV all these years along with the cops, and they kind of understand that, they're beginning to see that the police are a problem. It's, law and order. It's not that hard to switch to the other part of the state.
Yeah, I would say, just to add to that, I mean, I think it's tricky because, police are arguably the most frontline bureaucrats in the criminal justice system. Even people who don't commit crime actually see them. So I think that's one. I think two, we're just starting to get, there is just more video documentary evidence of police violence that's undeniable and unescapable in ways that Brady violations aren't as easily to see, or aren't as easy to see. I would say a couple of things. I think one, in terms of what can be done in terms of placing more spotlight on prosecutors. I think one is just to politicize them a little bit more. And I think that is happening by way of the proliferation of progressive prosecutors. And people have mixed ideas on that, about what progressive prosecutors are doing. So one, they're getting politicized in part because, at least publicly, they're taking a different approach to questions of punishment. It's publicly, ostensibly. One, I think two, they're becoming more politicized in part because, communities on the left are saying that they're not doing the things that they held themselves out as saying they were going to do. So I think it's a question around politicization. I think, when I think about that's 1A, 1B, 1C, we have, at least what the news is saying is that, one of the potential vice presidents is a former prosecutor. And so I suspect that that background is going to get politicized much more if Kamala Harris is chosen. I think there will be kind of more public language around the role of prosecutors. As I think happened, this lady's name's escaping me, Minnesota, Senator Klobuchar. There's some people who believe that her record as a former prosecutor ended up being disqualifying. And so I think there's a question around politicization. I think there's a question around the kinds of work we encourage students to get into. And this is hotly debated in terms of encouraging students to get into prosecution. I think there's one view that says we need progressive people in those spaces. Everyone can be a public defender. I think there's another view, I remember either reading it or maybe Paul Butler mentioning it at a talk, like he's of the belief that wanting to be a prosecutor for social justice purposes is like wanting to be a slave driver for social justice purposes. And so there's another view that says you just can't do this work. But I do think that it's a live question. There's a live question about whether people with social justice commitments should be going into prosecution. And I think the third thing comes back to, what I was describing earlier in terms of how we're training prosecutors. Whether people end up being prosecuted, whether progressives end up being prosecutors or not, people will become prosecutors. And if people are leaving law schools not understanding the content of some of the things that we've discussed today, as well as a larger literature and history around the criminal legal system's inequality, that doesn't strike me as changing the status quo. And so part of it might be tied to how we train future prosecutors.
Great. Thank you all both so much for those answers. So the next question says, so much of criminalization seems to come down not just to the letter of the law, this is building off the last question, but it's selective and racist enforcement by prosecutors and cops and through the budgets and other political mechanisms. What do you think is needed in this moment? And how do you see the role of legal scholarship in relation to complementary strategies?
I meant here, it's a very important question. I guess I'm less and less optimistic that we can essentially bleach out the selective and racist enforcement from the system. I feel like over the last 60 years or something of war on crime, we've been running a kind of science fiction-y, social science experiment to see if we can kind of separate the racist part of our criminal legal system from the public safety part of it. Now, put aside that the fact that it's not very good at public safety because it was never invented to do that, but forget that for a moment. I don't think we can actually get the racist part out. And it's not because the people involved are racist. Compared to the police of 1968, believe me, the police of every city are much less racist than those guys. Or even the police I met in Newark riding around for Jerry Skolnick in 1984. By every measure, they're less racist and there are more diversity, et cetera. Doesn't matter. We have so much interdisciplinary research now showing that as soon as crime fighting is your mission, an anti-Black axis, comes into operation. You can't even really stop it. Now, there's debates about how much you can train around it, et cetera. To me, what it means is abolition. And for me, abolition means working hard toward reducing our reliance on every aspect of the criminal legal system. It doesn't mean it's gone tomorrow. It just means that the best thing to do is not to worry about training out the bias. It's to see if we can just reduce our reliance on these actions that are defined by crime.
I would echo those comments, and now it might be a time to say, at least in terms of what academics can do, I think part of it is fight and not legitimate the status quo. And so, I'm part of a small group of scholars who I've had the pleasure of being welcomed into that are trying to encourage other law professors to rethink, other criminal law professors, criminal procedure evidence, and the legal professoriate more generally, to rethink the ways that our scholarship and teaching legitimize the status quo. So we drafted a letter just to express our commitments and solidarity to social movements that are demanding a certain kind of disinvestment from our very elaborate and extravagant criminal justice system. And part of this is an attempt to just kind of get professors to rethink their pedagogy, particularly in this moment after protests inspired by police violence, and during this moment of COVID, where people are really trying to think about teaching. And so I mean, for people who are interested, law professors that are interested, please feel free to contact me. But part of what we're trying to do is really encourage law professors to think about the role that their scholarship, their public writing, the research projects that they take on, their teaching play a role in legitimizing the criminal justice system. And that's what I was saying earlier, is we just don't think about law professors as inputs into this larger problem of mass incarceration. So I think part of it is just tied to law professors being better.
Thanks so much. Okay, so the next question, Brad asks, he says, I'd be curious to hear either of your thoughts about the relationship between segregation and the criminal justice system. In particular, it strikes me that the core of the abolitionist framework is in some respects about vesting power over governance decisions without policing, incarceration and criminalization in communities that have been marginalized by the criminal legal system. Segregation is obviously at the heart of that marginalization, but integration seems in tension with the solution. For instance, the YIMBY movement seems to reflect some of the more neoliberal or technocratic approaches to social issues and often rest on depriving local communities of power and control. How do you reconcile that tension?
Could you repeat that last part of the question one more time?
He says, for instance, the YIMBY movement seems to reflect some of the more neoliberal or technocratic approaches to social issues and often rests on depriving local communities of power and control, asking how you reconcile that tension.
I'll see this one to you, Jonathan. This is a chapter in governing through crime.
I'm not familiar with the YIMBY movement directly. I guess it's a play on NIMBY, perhaps, that a more positive attempt. But two things I will say. One, I mean, you simply cannot overemphasize the importance of segregation as a 20th century phenomenon. And remember, segregation, especially in its northern form and in some ways in its most codified Southern Jim Crow forms, is a child of eugenics. It's not a direct, inheritance from nostalgia for the Confederacy, right? I mean, the Confederacy wasn't about segregation. They were living very close to each other. It was about power, and it was eugenics that made it about race in a reproductive sense and in a population demographic sense, and led to an intense emphasis on segregation that has, never gone away, right? After World War II, we specifically segregated the suburbs. We created, these highly concentrated, segregated neighborhoods that became the core of what we then called the crime problem, which we blamed for the death of the cities that had, been killed by deindustrialization 25 years earlier. So I think segregation's a huge part of it. The current moment of possible gentrification-driven momentary integration, which may not happen anywhere because removal of poor people is happening so rapidly, could be an opportunity to rethink, public safety in ways that would help maybe sustain integration. But I agree with what I took to be the implication of the last point. We need to make sure that whatever we call reform or abolition ends up looking a lot like what people in these communities that have been the hardcore pressed victims of mass imprisonment and policing, what they want, what kind of options they want for safety. If it ends up being people like me with PhDs, maybe it's okay if it's somebody like Shaun with PhDs, at least from the neighborhood. But make sure it's not people who look like me, because we were doing the work back in the eugenic era too, trying to help everybody.
Okay, so I am actually going to skip to a question from a student. Tariq says, both of you touched on how the criminal legal system excludes race and poverty from analysis. As a student studying the system, it always frustrates me that the courts never seem to take account of personal circumstance, race, and data proving the system's racist and disparate impact. It often feels like this is an intentional approach to reinforce the system's legitimacy, as if contending with these realities would be equivalent to admitting the system is flawed. Given current movements are demanding state, federal, and local governments defund the police in favor of more social services and better funded public institutions, how can we carry this momentum into the classroom to invite students to challenge the foundational assumptions of criminal law?
That's a hard question. I think, you know, they say all politics are local, and I think that applies to legal education. And you know, I think I think what a couple things make it tricky. One is the fact that oftentimes, you know, students have an appetite for these kinds of conversations, but the bad faith understanding is that professors just don't want to do it or have these kinds of conversations, or they're not equipped to have them. The good faith understanding is that professors are genuinely trying to get through a lot of material. And sometimes these kinds of conversations can, quote, get in the way of the teaching objectives that the professor has for the day, for the week, etc. So that's one challenge. I think another challenge is what this questioner asked has been a long-standing complaint in the law student population, and it varies by school and composition. But part of the problem is law student bodies are transient groups, and so what ends up happening is, you know, the first year is hard to kind of have that kind of ideological contestation when, you know, people are trying to get good grades so that, you know, they can get whatever job they want, whether it be a public interest job, a job at a firm, you know, get a clerkship later. And then, you know, that's the first year. The second year, you know, typically is where there's a lot of student organizing. And by the third year, depending on the school, most students are checked out. You know, Mitu Jalati and David Wilkins have this article from maybe like 15 years ago that said, like, based on the study, it was like something like 1 out of every 5 3Ls didn't go to class. And so I think part of the challenge is around having early and a set of early and sustained organizing efforts around forcing law schools to have their instructors do better when it comes to these issues, whether it's in the classroom, and that's hard because the classroom is, you know, every professor's own little fiefdom, or when it's just around questions around programming, questions around professional development, supporting student groups that want to have more robust conversations around this. So I think part of it is just early and sustained student activism that it will likely have to outstrip the 3 years that the students are in the institution. And I think part of it is, like, you know, one of the, you know, the reality is, whether you're talking about critical race theory on the far left, or you're talking about the Federalist Society on the far right, those were both movements that were inspired by students. And so sometimes some of that stuff's just gonna have to happen outside the classroom. Yeah, that's just kind of part of that challenge. But I think applying pressure on the administration when it comes to questions of hiring, programming, teaching requirements, et cetera, I think are a couple of possibilities.
Just briefly, I totally agree with that. It's also possible that, you know, at least those of us with tenure who aren't too worried about teaching evaluations and whatnot can try reinventing the course. You know, it doesn't have to be the equivalent of contracts or something. It could be an interdisciplinary course as part of the first year that looks at how the legal system affects people in a little bit broader way. One good news there, one thing that I'm excited about in terms of academic trends, is that focus on moral philosophy, which tends to make criminal law look away from the racial and social implications of it, is increasingly contested within the criminal law theory space by what is sometimes called the public law or approach to criminal law. And that requires us to ask questions about democracy, about equality, as well as about sort of whether it public safety is being effectively carried out or not. So that's one, way in which to encourage the class to think more about what values they want to see in the criminal legal system, not just retribution, deterrence, reform and incapacitation.
Thank you all so much. So we're almost out of time, but I promised that I would let my co-host Luke Herron ask a question about political economy, and then we'll offer both of you all a chance for any sort of final words or wrapping up.
Thanks, Corinne. I just wanted to bring, because we touched a bit, and by we, of course, I mean you, touched a bit on how the theory that what happened with the neoliberal turn in penality was the withdrawal of the welfare state and the sort of replacement with the penal state. And that's, as Shaun said, that's a contested notion, but it's a sort of common way of framing it. So I'm wondering, just sort of more generally, how do you think about the relationship between the criminal legal system and the welfare state, but also political economy and the way the political economy is governed? Political economy, more traditionally understood as sort of not including the criminal legal system, although maybe you would include those things. And so more in particular, to think about how this might approach the present moment, like, is it possible to think about reforming the criminal legal system and having an abolitionist movement without thinking about political economy more generally, how redistributive systems work, how systems of production work and distribution work, how markets are structured, or what is excluded from the market and the like? To what extent do you see sort of the criminal legal system filling gaps in political economy, and to what extent do you see it you can do some autonomous reforms without touching that space? Which is a very broadly worded question, but it's sort of an invitation for you to sort of treat those themes as you see them in the current moment.
I mean, I'm curious to hear what Shaun's take on it is. I mean, I think that, if you look at the history of the criminal legal system, essentially every part of it arose as part of an effort to protect essentially emerging forms of capital accumulation from the ways in which poor people were able to threaten them. So, the police were invented to prevent commodity capitalism essentially from being strangled in its cradle by workers who wanted to reacquire their surplus value by taking the goods directly at the port or in riots, etc. All along, this has been about that. And so one of the good news, if you want the good news is I don't think the emerging political economy, and I don't purport to understand it, but whether it's, tied to surveillance capitalism or technology capitalism of some sort or entertainment capitalism, my gut is that it doesn't really need the carceral state much anymore. That most of those things that the carceral state was invented to sort of protect capital against, capital's not exposed to much anymore. Think about retail, right? I mean, the police were supposed to protect retail. It may not exist, by the time we go back outside. You can protect packages on your store, on your door, or on your doorstep without the police, frankly, and they're not there to do that anyway. So I think the good news is that it's mostly our own politicized myths about race that are anchoring us to the current version of the carceral state. But I agree. I do think the welfare, it's a bit overly simplistic, but it's still helpful. It can't be just autonomous reform. Abolition has to go hand in hand with not reinventing the 1960s welfare state, which was still way too eugenic, but some kind of newly imagined form of welfarism.
Yeah, so you kind of mooted much of the point I was going to make, but I'll just add to that by saying, one of the interesting things. Sorry, I don't know if you can hear that. Some loud rock and roll passed by my place. One of the interesting things that I think we're witnessing right now because of COVID is how it's forcing politicians, criminal justice bureaucrats to rethink the role of punishment. I think particularly for many of the low-level crimes that lead people to populate our jails and prisons, but mostly jails. And I think it kind of reminds me of kind of about a decade ago, when the kind of right on crime movement started, when there were kind of like version economic conservatives who were concerned around the economic sustainability of the criminal justice system. And I feel like there is a version of that happening right now, which I think in some ways, I don't know the adjective for it, because I don't think it should take a global pandemic to inspire that kind of rethinking. But that's a thing. And it read through the limited lens of criminal justice politics, perhaps that's a positive thing, but it also strikes me as potentially ephemeral. And I think that is one of the I think exciting things about the kind of calls to think about how we fund police and shifting those resources to social services. That strikes me as a more sustainable model of thinking about the thinking about political economy and thinking about the welfare state vis-a-vis the penal state, than COVID-inspired decarceration. And I think, I'm not sure, but I think that's what leads me to agree with Jonathan's point about, the really lack of necessity of the penal state, even for people who are supporters of it.
That seems like a wonderful place for us to conclude. I want to again express our gratitude to our presenters for both their time and insights, and for the amazing questions from all of you. Hopefully you'll join us next week for our session on US Empire with Aziz Rana and Asla Bali. And thanks again for really a great session.
Thanks, everyone.